Despite the COVID-19 pandemic disrupting almost all professional events, on July 23rd, Legal Plus and L2 Icon jointly managed to hold the fully virtual Construction Claims and ADR Conference 2021. The conference was participated by 44 moderators and speakers from 9 jurisdictions. With such a star-studded lineup, we had high hopes the conference would be a success, and true enough, the conference achieved its target by seeing an incredible 1,534 registrations. Not only that, the conference also set a new record in the Malaysian Book of Records for the longest non-stop virtual construction and ADR conference, when the conference ended after a 12-hour marathon at 9 pm. Although the conference ended on July 23rd, its impact is still ongoing, and it is why we organized this charity premiere to let the conference see the light of day again, and at the same time to show compassion and empathy in our community. Let's watch the show together. It was this experience that became the spark for us wanting to help more people. We approached charitable organizations that help feed the poor, needy, homeless, orphans, abandoned, refugees, mentally disabled children and adults, the handicapped, animals, medical care, and help for children's education by providing used laptops and computers. If there is one thing we learned during the course of this initiative, is that there are many good people in our society, and many charitable organizations are going above and beyond to help those around them. For this charity premiere, we have carefully selected 10 charitable organizations, and we implore you to donate. Even a small amount goes a long way for them. 100% of the funds collected will be distributed equally. This initiative also helps raise awareness, the work these organizations do, and the people they have an impact on. This is the very reason why we are organizing this charity premiere, and with your help, we can help those who help others. Several landmark court case rulings have led to an increase in the number of claims from home buyers against developers for liquidated damages on the grounds that there was a delay in the delivery of vacant possessions of their houses. During this session, the panel will discuss the application of these decisions and their impact on developers, contractors, and the property development sector in Malaysia as a whole.
A very good evening to all 932 delegates, and thank you so much for staying on to 7:41 p.m. to listen to this session. I hope you will find it educational. Now, let me very quickly introduce our three speakers. They're very eminent. The first of whom is Sudha. So Sudha has a lethal combination of qualification of accounting, finance, and law from Monash, and added to that a master's from London School of Economics. He's a senior partner of the largest boutique litigation firm of Stephen Thiru and Sudha. He has 24 years in the bar with breadth of experience from agency law to revenue law. He has dozens of reported cases in his name. He is the immediate past president of MIR, and he's ranked in international law directories. The second speaker, if I can quickly introduce, is Taya. Hopefully you can see him on the screen. Taya is from King's College, founder and partner of Bhaskaran. His primary practice is in construction law, both contentious and non-contentious. He is the past president of the Society of Construction Law Malaysia, and despite his busy practice, Taya is also a writer, having written books on Belt and Road Initiative and arbitration law. Like Sudha, Taya is also ranked by international law directories, where he's been described as skilled and knowledgeable in the area of arbitration law, and Taya is the best example of the new wave of Asian practitioners who offer great talent and fresh ideas. He's incredibly smart, agile, and resourceful. The third speaker is Nyak, and he is in the wave next to Taya, who's another talent with fresh ideas. Nyak is a partner in one of the top full-service law firms, Christopher and Lee Ong. Nyak practices in corporate and commercial disputes, shareholder disputes, engineering and construction disputes, among others. Like Taya, Nyak is also a writer, having contributed to textbooks on injunctions and to mainstream newspaper. I now invite Sudha to share his views on the federal court decision in Ang Ming Lee, which has created so much litigation for us lawyers. Over to you, Sudha.
Thank you, Dr. Lim. Thank you to the organizers for inviting me, and good evening to all the delegates. So my presentation this evening will focus on two cases. The first is the decision of the federal court in Ang Ming Lee. The second is the decision of the High Court in Alvin Leong and two other cases. The three cases were heard together. A decision of the High Court, which is now on appeal to the Court of Appeal. Arguments have been heard in the Court of Appeal. A decision is pending and due to be delivered on the 29th of July. Dr. Lim is counsel for the developer in the matter. I make that disclosure on his behalf, although he has got no vested interest in the discussion this evening. Now, let me share my PowerPoint presentation, if I can. Yes. Okay. Right. Okay, before I begin with my PowerPoint presentation, I thought it may be helpful for those of you who are less familiar with Ang Ming Lee, for me to make some brief introductory remarks. So my first introductory remark is this. Being a decision of the Apex Court, Ang Ming Lee is important, indeed very important. But there are some decisions of the federal court which are more important than others. And in my view, the Ang Ming Lee case falls into the first category of decisions and not the second category of decisions. Furthermore, Ang Ming Lee is notable because it is a bold decision. Now, why do I say it's a bold decision? First, it is quite rare, indeed exceptional, for an executive order or a subsidiary legislation to be struck down by the courts on the ground that it is ultra vires. Such cases are few and far between, and rightly so, because when an executive order or a subsidiary legislation is struck down on the ground of ultra vires, it can result in a great deal of uncertainty and cause a great deal of disruption. Second, Ang Ming Lee overrules approximately 30 years of accepted, established, indeed entrenched practice in the real estate sector. Thirdly, Ang Ming Lee is said to have heavy financial consequences for developers and by extension, the real estate sector, for financiers and by extension, the financial sector, and beyond that, for the economy as a whole. Which leads me to ask the question, was the federal court's decision anticipated? I refer here to the federal court's decision as opposed to the outcome of that case. I suggest the outcome was anticipated, but I suggest that the decision itself was perhaps not anticipated. And the reason I say that is because there was a narrow issue for determination by the federal court, and there was the broader ultra vires issue, which was also up for determination by the federal court. The federal court decided the narrow issue in favor of the purchasers. The federal court could very well have stopped there and not gone on to deal with the broader ultra vires issue. But the federal court did so and went on to hold that the executive order subsidiary legislation in that case was ultra vires for reasons I will elaborate upon. So that in turn leads me to ask why the federal court felt that it was necessary to go beyond the narrow issue and decide the broader ultra vires issue if it would not alter the outcome. Perhaps I can leave that question for discussion during Q&A. And with those introductory remarks, perhaps I should begin by explaining the case. Now, thankfully, for an important case, the facts of the case are mercifully simple and straightforward. So you'll see in front of you a time chart. And the events in this case started in May 2012, when the developer entered into a series of sale and purchase agreements with individual purchasers for condominium units. The sale and purchase agreements were in the statutorily prescribed form under Schedule H of the regulations. And the regulations here are the Housing Development, Control and Licensing Regulations 1989, which provide that vacant possession must be delivered within 36 months. And failure to deliver vacant possession within 36 months will give rise to the purchaser's entitlement to sue the developer for liquidated ascertained damages. So 36 months being the time period to deliver vacant possession. In October 2014, before the 36 months period expired, the developer applied to the housing controller for an extension of time for delivery of vacant possession of the condominium units to the purchasers under Regulation 11 sub 3. I will show you all Regulation 11 sub 3 in a short while, but let me just finish the factual background. Shortly after the application was made, the controller responded to reject the EOT application. It's interesting that the controller rejected the EOT application. Now, the developer, being dissatisfied with the controller's decision, then appealed to the minister pursuant to Regulation 12. And on the 17th of November 2015, the minister purportedly allowed, and I will explain later why I say purportedly allowed, the developer's appeal and granted an extension of time of 12 months to the developer. So I promised that I'll show you all Regulation 11. And what I have here is almost the whole of Regulation 11. So 11.1 is in front of you. I don't propose to deal with that at this point, perhaps later. 11.1a is also before you, and I may deal with it later. 11.1b is also before you, and I will deal with it later when I deal with Alvin Leong. But it's 11 sub 3 that was the subject of the federal court's decision in Ang Ming Lee. And what Regulation 11 sub 3 says is where the controller is satisfied that owing to special circumstances or hardship or necessity, compliance with any of the provisions of the contract of sale is impracticable or unnecessary, he may, by a certificate in writing, waive or modify such provisions. There's a proviso to Regulation 11 sub 3, but it's not relevant for present purposes, so I won't take time reading it out. I move on to Regulation 12, which was also a regulation that was in focus in the Ang Ming Lee case. And Regulation 12 reads, notwithstanding anything to the contrary in these regulations, any person aggrieved by the decision of the controller, and I skip to line 3 to the part that is highlighted under paragraph 3 of Regulation 11, which I just read out, may within 14 days after having been notified of the decision of the controller, appeal against such decision to the minister, and the decision of the minister made thereon shall be final and shall not be questioned in any court. So that's how Regulation 12 reads. The effect of the 17th November 2015 decision is what I wish to now turn to address. First, the developer now had 48 months to deliver vacant possession of the condominium units to the purchasers, as opposed to the original 36 months. As a result, the purchasers were unable to claim LAD from the developer. So being aggrieved by the 17th November 2015 decision, purportedly by the minister, the purchasers filed a judicial review application naming the minister, the housing controller, and the developer as the respondents in the judicial review application and sought the following relief. First, an order of certiorari to quash the controller's decision dated 17th November 2015. So contrast that with what I've been saying all this while, the purported decision of the minister. The prayer sought was to quash the decision of the controller dated 17th November 2015. I'll explain why later. Secondly, a declaration either jointly or in the alternative that the letter dated 17th November 2015 signed by one Jayasilan Navaratnam on behalf of the controller is invalid and is beyond the jurisdiction stipulated in the Act. Now, that is the narrow issue. And the further declaration that was sought is a declaration that Regulation 11 sub 3 is ultra vires the provisions of the Act. That is the broader ultra vires issue. So I start by discussing very briefly the issues before the High Court and the Court of Appeal, because this is of interest. Number one, the first issue before the High Court and the Court of Appeal was whether Regulation 11.3 of the regulations is ultra vires, the broad issue. The second issue, the narrow issue, whether the letter or decision of 17th November 2015, in which the 12 months extension was granted, was made without jurisdiction and therefore is invalid and of no effect. And the other narrow issue, whether the purchasers ought to have been given a right of hearing prior to the decision made by the controller and or the minister granting the developer the 12 months extension of time. How did the High Court decide? So the High Court answered the first question in the affirmative, and indeed answered the second question also in the affirmative, but did not provide an answer to the third question. The developer then appealed the High Court decision to the Court of Appeal. And the Court of Appeal, by contrast to the High Court, and I'm sorry to jump around, the Court of Appeal, by contrast to the High Court, decided the broad ultra vires issue in favor of the developers or the developer, holding that the regulation is not ultra vires because the regulation, in the Court of Appeal's view, was consistent with the broader intent and purpose of the Housing Development Control and Licensing Act. But the outcome before the Court of Appeal remained the same. To say the decision of the Court of Appeal was in favor of the purchasers because the Court of Appeal answered the two narrower questions in favor of the purchasers. That is to say, the Court of Appeal answered the two narrower issues in the affirmative, having answered the first issue in the affirmative. So that's an interesting point to stop and to pause and to reflect. So you have three issues: the broad ultra vires issue and the narrower issue, issues involving natural justice and the validity of the 17th November 2015 decision. Now, the validity of the 17th November 2015 decision turned on whether the decision maker was the minister or the controller, a very narrow issue. The purchasers were successful both in the High Court and in the Court of Appeal. But despite being succeeded in the High Court and the Court of Appeal, the purchasers applied for leave to appeal to the Federal Court against the decision of the Court of Appeal in deciding the broad ultra vires issue against the purchasers and in favor of the developer. The developer, in turn, applied for leave to appeal against the decision of the Court of Appeal arising from the two narrower issues. That leave application, both leave applications were allowed by the Federal Court, and 5 leave questions were formulated for substantive hearing before the Federal Court. The first 3 questions were questions that were framed by the purchasers, and the final 2 questions were questions that were framed by the developer. Now, I'll read the questions out because they are important. The first question was whether the housing controller has the power to waive or modify any provision in Schedule H, contract of sale, as prescribed by the minister under the HDA, that's the Housing Development Act. Question 2, whether Section 24 of the HDA confers power on the minister to make regulations for the purpose of delegating the power to waive or modify the Schedule H contract of sale to the housing controller. And question number 3, which really flows from the first two questions, whether Regulation 11 sub 3 of the Housing Development Regulations is ultra vires the Act. So all three leave questions framed by the purchasers dealt with the broader ultra vires issue. On the other hand, the questions by the developer were as follows. Question 4, whether the letter, and this is the 17th November 2015 letter granting extension of time after an appeal pursuant to Regulation 12 of the regulations, must be signed personally by the minister, and whether the minister could delegate his duties, signing of the letter granting the EOT, to an officer in the ministry. And question 5, whether the minister, having taken into consideration the interest of the purchaser, is obliged to afford the purchasers a hearing prior to making his or her decision. So this is how the federal court answered the 5 questions, beginning with the first question. Now, the first question dealt with the issue of whether the controller had the power to extend time under the Act and the regulations. And this is how the federal court answered that question. The Act has specifically enumerated the duties and powers of the minister and the controller. Where powers or duties may be exercised by the controller, that has been made clear by the Act. On the above analysis, we hold that the controller has no power to waive or modify any provision in the Schedule H contract of sale, because Section 24 of the Act, which I will show you all next, does not confer power on the minister to make regulations for the purpose of delegating the power to waive or modify the Schedule H contract of sale to the controller. And it is not open for us to read into the section an implied power enabling the minister to do so. We consequently hold that Regulation 11 sub 3 of the regulations conferring power on the controller to waive and modify the terms and conditions of the contract of sale is ultra vires the Act. So this is how Section 24, insofar as it is material, reads. Subject to this section, the minister may make regulations for the purpose of carrying into effect the provisions of this Act. Subparagraph 2, in particular and without prejudice to the generality of the foregoing power, the regulations may regulate and prohibit the conditions and terms of any contract between a licensed housing developer, his agent or nominee, and his purchaser. So that brings us on to question 2, whether Regulation 11 sub 3 is consistent with Section 24 of the Act. So this is how the federal court answered that question. Having prescribed the statutory form H in Regulation 11.1 and the terms and conditions for the contract of sale, the minister by Regulation 11 sub 3 then empowers the controller to waive or modify the conditions and terms of the contract of sale as prescribed in Schedule H. This begs the question whether by empowering the controller to waive or modify the conditions and terms of the contract, the minister has exceeded the scope of the authority conferred on him by the legislature. It is the minister who is entrusted or empowered by Parliament to regulate the terms and conditions of the contract of sale. The minister, however, has delegated the power to regulate to the controller by regulation 11 sub 3. As power to regulate does not include the power to delegate, the minister's action in delegating the power to modify the conditions and terms of the contract of sale may be construed as having exceeded what was intended by Parliament. So just to remind you all as to what Section 24 says, it talks about a power to regulate that is vested in the minister. There's no reference here to a power to delegate, and that is the point that the Federal Court sought to make, especially in paragraph 51. Then in paragraph 56, the Federal Court went on to conclude on this point that by delegating the power, vide regulation 11 sub 3 to the controller to waive or modify the prescribed terms and conditions of the sale of contract, it is now the controller who has been entrusted to regulate the terms and conditions of the contract of sale. And I skipped these two slides, which I'll come back to later. And in paragraph 60, the Federal Court answered question 3, which arose from question 1 and 2. We consequently hold that regulation 11 sub 3 of the regulations conferring power on the controller to waive and modify the terms and conditions of the contract of sale is ultra vires the Act, and in particular, ultra vires Section 24. Now, the Federal Court then went on to deal with question 4 and question 5. But the Federal Court deemed that it unnecessary to deal with both questions 4 and questions 5 because they were based on an incorrect factual premise. What the Federal Court said in response to question 4 was, on the facts of this case, there being no decision by the minister under Regulation 12, we declined to answer question 4, and the same reasons were given for not answering question 5. So I promised that I would explain why the Federal Court held that the 17th November decision was not the decision of the minister. And that is obvious from this letter, the letter of the 17th of November 2015, which I have now shared in front of you. The first thing you will note is the person who has signed this letter is not the minister, but one Jayaseelan Navaratnam. The second thing you will note is that Mr. Jayaseelan was signing the letter, again, not on behalf of the minister, but on behalf of the controller. So based on that factor, one factor, the Federal Court said this is not the minister's decision, it is the controller's decision. In addition, the Federal Court looked at the body of the letter and noted that reference was made in the letter not to Regulation 12, which is the regulation that speaks of the appeal to the minister, but of Regulation 11, which speaks to the power of the court. So for those two reasons, the Federal Court came to the conclusion that this was not the decision of the minister. Now, in the upshot, the purchasers were able to claim LAD against the developer based on a 36-month period instead of the 48 months that was granted to the developer under the 17th November 2015 letter. So I stop here because that's what I wanted to say about Ang Ming Lee. I'll come back to deal with Alvin Leong perhaps in Q&A so that my fellow speakers can make their presentations. Thank you, Dato. I hand over to Taya. Taya, over to you.
Thank you.
Hi, good evening. Good evening, everyone. It's a pleasure to be here. I see that it's just past 8 o'clock, and I'm very glad to see that more than 900 of you are still here with us this evening. Thank you very much to the organizers for inviting me to speak. I will this evening be speaking to you on recent developments with regards to liquidated damages that can be recovered by a purchasor. I will be focusing on three main developments. One is the federal court's judgment in PJD Regency. Next, the Court of Appeals judgment in Low Tina. And finally, the impact of the COVID-19 Act 2020 on the liquidated damages that may be recovered. Before I go into these judgments and the COVID Act, because PJD Regency to a large extent deals with the timelines under the Housing Development Act for the recovery of liquidated damages, I will just set out those timelines for you all. In that regard, if I can now perhaps try to share my slides. Yes, and you can see here the timelines that are applicable to the recovery of liquidated damages under the Housing Development Act. So you have a start date for the delivery of vacant possession, which is meant to be the date of the SPA. Some controversy arose about this within PJD Regency. Then from that date, you have 24 or 36 months for the end date for the time for delivery of vacant possession. This is also the start date for liquidated damages. And if the property has not been delivered and the delivery is delayed, then liquidated damages can be recovered up to the date there is delivery of vacant possession. Again, insofar as common facilities are concerned, there was some issue and controversy on this in the judgment in PJD Regency. I now turn specifically to the judgment in PJD Regency. So as I mentioned earlier, two issues arose in PJD Regency. Firstly, with regards to the start date for the running of the 24 or 36-month period for the delivery of vacant possession, should that run from the date of the SPA, or should that run from an earlier date on which the booking fee had been paid? And the second issue is with regards to the common facilities. When were liquidated damages meant to end in relation to the common facilities? Was that meant to be based on the Certificate of Practical Completion, which is the CPC, or the Certificate of Completion and Compliance, which is the CCC? So what the federal court decided was that insofar as the start date for the delivery of vacant possession is concerned, they would use the earlier date of the date on which the booking fee was paid rather than the date of the SPA. And insofar as the end date for liquidated damages was concerned, insofar as it relates to common facilities, they would use the CCC date and not the CPC date. Yeah. So you would appreciate that in both contexts, the time period for which liquidated damages are to run are being expanded upon. You know, on the front side, it's being pulled forward, and on the back end, it's being pulled later, both of which are favorable to the purchaser and less favorable to the developer. Yeah. So why did the federal court use the earlier date of payment of the booking fee as the start date for the delivery of vacant possession? Firstly, the federal court, so they gave essentially 5 reasons. These 5 reasons to some extent overlap with each other, but I have divided them into these five primary grounds in order to make the point clearer. So firstly, they said that they would use the date on which the booking fee was paid, although the SPA expressly provided that the start date would be the date of the SPA. And the reason for that was the federal court held that the Housing Development Act should be interpreted purposively. It shouldn't just be interpreted literally. And the reason for that was that the HDA is regarded as a piece of social legislation. It's called a piece of social legislation because it expressly states that it has been enacted for the purposes of protecting house purchasers. And because of that, the federal court said that they would give it an expansive, wide meaning. And although the SPA, in its black and white, it says that the start date is the date of the SPA, they would use an earlier date from which the 24 months and 36 months are to run, which is the date on which the booking fee is paid. Next, the federal court held that the collection of a booking fee is expressly prohibited and illegal. The reason for that is that a reading of the HDA and the SPAs found in Schedule G and H show that the deposit of 10% is only to be paid when the SPA is signed. So the practice of collecting a booking fee earlier before an SPA is signed, although that is a common and wide practice in Malaysia, is something which is strictly illegal and prohibited. Thirdly, the federal court held that although the collection of the booking fee was illegal, it would not render the SPA void. Instead, the purchasers would still be entitled to enforce their remedies under Schedules G and Schedule H. In this instance, the remedy which the purchasers would be entitled to recover would be liquidated damages, where the period for delivery of vacant possession would run from the date on which the booking fee was paid. Fourth, the federal court held that the developer's collection of a booking fee and the signing of a pro forma agreement meant that an agreement for all intents and purposes had already been reached between the purchaser and the developer, even if the formal SPA was only entered into later. And finally, the federal court held that they must use the earlier date of the booking fee and not the later date of the SPA, because if they were to use the later date of the SPA, then there was a risk that developers may intentionally date the SPA later in order to postpone the period for the delivery of vacant possession and reduce the amount of liquidated damages that are to be paid. The federal court then on the next issue of when the liquidated damages for CCC runs, when that ends, insofar as common facilities are concerned, the federal court held that that would only run, that would end on the date that the CCC is issued and not the earlier date on which the CPC is issued. This is again despite the fact that the SPA in Schedules G and H do not expressly link the common facilities to the issuance of CCC. But the federal court held that there's only one type of certification which is referred to in the SPAs in Schedule G and H, and this is the CCC. And therefore, logically, for the purposes of the completion of the common facilities, it must mean that a CCC has been issued as opposed to a CPC. Secondly, the federal court in this context held that there is a different purpose that is served by a CPC and a CCC. A CCC is a requirement of law. It is issued pursuant to the Street Drainage and Building Act, and it offers house purchasers protection insofar as the relevant authorities have checked and approved the construction. Whereas the CPC is not a matter of public law, it's actually a matter of private law. It arises pursuant to the building contract that has been entered into between the owner and the contractor, and the CPC is issued by an architect to show that the contractor has completed the construction work to the architect's satisfaction. So the CCC and the CPC play quite a different role. And insofar as the SPAs are concerned, in order to indicate completion of common facilities, the proper certificate to refer to is the CCC and not the CPC. So that in a nutshell is what was decided in PJD Regency. I now turn to the next case, which is the case of Low Tina, which has been recently decided by the Court of Appeal. This is quite an interesting case. It doesn't really deal with liquidated damages, but I will try to draw some sort of connection with liquidated damages later on in my discussion. But it's interesting because it deals with a fairly widespread practice now of what is known as a private lease scheme, or a PLS for short. And so what happens under this private lease scheme? Under a private lease scheme, what essentially happens is this. You have a proprietor who is the freehold owner of the land. And what he then does is he then gives a lease to the, he then agrees with the developer that the developer may develop the land. And he also agrees that the purchasers, that he agrees with the purchasers to grant them a lease of the land of 99 years with an irrevocable option to extend that lease further for a further 99 years. Yeah. So you will immediately see that this is quite different from a normal housing development where the purchasers, acquire ownership of the house. Here, it is essentially what's being done in a nutshell is that the proprietor is giving the developer a lease of 99 years, and then the developer is then subleasing that to the purchasers. Yep. To be fair to the developer in this matter, he actually did recognize that, and he very substantially amended the SPA, and even went to the extent of renaming the SPA a build and lease agreement to reflect the private lease scheme. He then applied to the Controller of Housing for approval of the scheme, but such approval was not granted. Despite that, here the developer didn't act so well. He still proceeded with the scheme. And subsequently, the purchasers contended that the scheme was prohibited under the HDA and asked for the freehold title to be transferred to them. So the issue, the issue which several issues arose in Low Tina, but I'm going to focus on one issue in order to draw a sort of connection with liquidated damages. So the issue that arose in Low Tina is whether a developer of a private lease scheme comes within the meaning of the HDA. As I mentioned earlier, at first glance, you look at a build and lease agreement, you look at a lease, you don't really think, prima facie, this really comes within the HDA. All of us sort of understand that as a situation where, the property is being developed and is then subsequently transferred to people. Ownership is being transferred. And that was what was argued successfully in the High Court, but that was overturned in the Court of Appeal. So in the High Court judge accepted that because there was no transfer of ownership of land pertinent to the housing accommodation within the meaning of the HDR, there was no housing development as such under the HDA because there was no sale, there was merely a lease. However, the Court of Appeal did not accept this and held that the developer did come within the meaning of the HDA, and as such, the SPA must comply with Schedule G. So any provision that was non-compliant with Schedule G would be rendered void, and the purchaser would be entitled to enforce the agreement in terms of Schedule G. Yeah, regardless of what was in their agreement, they would be entitled to enforce Schedule G, and pursuant to that, they were allowed to have the property freehold in the property transferred to them. Despite entering into a build and lease agreement, they ended up owning the property. The purchasers actually had the property transferred to them. Yeah. I'm now going to try to draw some sort of connection between this and liquidated damages, which is the topic of the session. So it was emphasized in Low Tina that it would be very difficult to contract out of the HDA. Yeah. So any attempt to get around PJD Regency, the expansion of liquidated damages in PJD Regency by way of contracting out without the approval of the Controller of Housing is likely to be unsuccessful. The Court of Appeal in Low Tina also cautioned developers and proprietors against failing to comply with the HDR. And quite interestingly, also specifically cautioned directors and legal advisors from aiding or counseling such non-compliance, which amounts to an offense under the express terms of the HDA. So that caution is expressly given in Low Tina and should, taken quite seriously by anyone interested in doing some interesting drafting to get out of PJD Regency. Yeah. Okay, so that then wraps up Low Tina, and I move on now to the third issue, which is with regards to the COVID Act 2020. The Act actually has a very long name, Temporary Measures for Reducing, so on. But I think for convenience, everyone just calls it the COVID Act 2020. So the COVID Act 2020 specifically deals with these two issues which I was discussing earlier. One with regards to the delivery of vacant possession, and the other with regards to liquidated damages. And in basically, if you think back to the timeline which I set out at the beginning when I first started discussing this topic, they've basically taken out the time slice from that. Yeah, so 18 March 2020 to 31st August 2020. 18 March, if you recall, was the date on which the lockdown started last year. And 31st August, well, it's Independence Day. I don't really know what the significance of it is. Anyway, so for that period of time, that's removed from the calculation of time for delivery of vacant possession, as well as for liquidated damages. That can be further extended up to 31st December 2020. And in that regard, an application needs to be made to the minister. Yeah. So that is the impact of the COVID Act 2020, the relief that has been granted by that act insofar as vacant possession and liquidated damages are concerned. So that essentially brings me to the end of my presentation. Just say for some maybe parting words with regards to some potential reform to the law in light of the decisions in PJD Regency and Low Tina. Insofar as PJD Regency is concerned, rather than having two sets of dates for the start date for vacant delivery of one, the start date of the SPA, and the other, a potential date of the booking fee, which has been decided on by the federal court in PJD Regency. Perhaps, to avoid this inconsistency, the Act should be amended to specifically deal with this rampant practice of collecting booking fees, and expressly provide that regardless of when the booking fee is, regardless of the date of the SPA, the date on which the booking fee is paid will be the date from which the 24 months or 36 months runs. Insofar as the issue of the CCC is concerned, I mean, as far as I can see it, that seems to be merely a drafting issue, and the completion of the common facilities should simply be linked expressly to the CCC being issued. Insofar as Low Tina and PLS private lease schemes are concerned, that really opens up, a lot of areas for consideration, which I will take up perhaps later in the session during Q&A. Thank you. Thank you very much.
Thank you, Taya. Nyak, over to you.
Thank you, Tanya. Thank you, Dr. Lim. It is a pleasure today to be with 921 participants. And note that it was about 1,300 participants in the morning. So for those 921 participants that stay on to until now, I'm sure that each of you have a very fruitful event today. So as the last speaker for the last event, so I will keep my presentation short and sweet. Let me start sharing my slides. It is undisputed that the LAD is one of the major concerns in the housing development industry. Mr. Studer has talked about Ang Ming Lee, and Mr. Tai has talked about PJD Regency. What I intend to do today is to zoom in to certain issues that may arise post Ang Ming Lee and post PJD Regency, and explore with the audience today what may be the possible actions that the developer may take to mitigate the effect of Ang Ming Lee and PJD Regency. So effectively, I have 4 topics to share with the audience today. First is the retrospectivity and the prospectivity of Ang Ming Lee. Second, the position of the Real Estate and Housing Developers Association. Third, the aftermath of PJD Regency. And as I said just now, the possible solutions for housing developers. So generally, all written judgment of the courts have retrospective application unless expressed otherwise. This is a general rule. So in the ordinary course, the function of the court is adjudicative, and therefore the court decides on the legal consequence of past happenings. So for example, in the case of Ang Ming Lee, the court was asked to decide the validity of EOT granted by the housing controller prior to the case of Ang Ming Lee itself. So which is the law that governs the validity of the housing controller at the time when Ang Ming Lee was before the court to decide, which was granted prior to the case that come before the court. So the effect of this retrospective application is this: all EOT granted by the housing controller to the developers prior to the Ang Ming Lee case is invalid and or illegal. And that has a far-reaching effect, especially to the approvals obtained prior to the entry of the SPA, which is the pre-approvals obtained by the developers prior to the entry of the SPA, as it can be seen in the case of Wing Leong. And therefore, the clock starts ticking when the SPA is signed. The trigger will be pulled at the expiry of the 24 months if it is under Schedule G, or it is 36 months under Schedule H. No extension can be deemed valid if it is an EOT granted by the housing controller. Now we come to the issue of prospective overruling. Well, the issue of prospective overruling is a topic where it can take up to a day to discuss, because it is a very dense topic, and if you were to deep dive into it, it would take a very long time for us to do so. So the purpose of today's presentation is to give the audience an idea what does it mean by prospective overruling. So simply put, okay, there are 2 forms of prospective overruling. The general form, first is pure prospective overruling, which it means that the court's ruling applies exclusively to the events that occurs after the date of the decision. So selective prospective overruling means prospective in its effect, but retrospective with regard to the parties to the current proceedings. So to give an example, what does it mean? I take the example for pure prospective overruling. If pure prospective overruling were to be applied in Ang Ming Lee, the EOT granted by the housing controller will be valid including the decision in Ang Ming Lee itself, including the EOT obtained by the housing developer from the housing controller in Ang Ming Lee itself. So for selective prospective overruling means that the parties to the EOT granted to the developer by the housing controller in Ang Ming Lee is not valid. So does the EOT granted subsequent to the decision of Ang Ming Lee. But the EOT granted to the developer prior to the decision of Ang Ming Lee will remain valid. So as the audience can see, this is a discretionary tool designed to mitigate the adverse effect of the retrospective change, right? So let's look at some cases where the court invoked the doctrine of prospective overruling. In the famous case of Semenge Jaya, the federal court declared that Section 40 of the Land Acquisition Act 1960 to be unconstitutional with prospective effect, so that previous decision made under the invalid law will not be affected. In the case of PP against Datuk Yap Peng, the Supreme Court declared that the Section 418 of the Criminal Procedure Code to be unconstitutional and void, being an infringement of the Federal Court Constitution, and therefore applied the doctrine of prospective overruling so that the conviction or acquittals under the section prior to the date of the judgment remain undisturbed. Now we come to another famous case of Sinaya. The Federal Court ruled that the previous decision and held that the standard of proof of fraud is now on balance of probability and no longer beyond reasonable doubt. And judgment only applied to the appeal, which is selective prospective overruling and future cases. And therefore it could not be used to set aside or review the past decision involving fraud in civil claims. In the case of Soposhing against Malaysia Banking Berhad, the Court of Appeal ruled that the Federal Court decision in Dr. Samsul Bahar against IHB Bank was prospective in its effect. What effectively happened in Dr. Samsul Bahar is that the Federal Court held that in order for the judgment creditor to commence bankruptcy proceedings in relation to the judgment that is more than 6 years old, a leave of the court has to be obtained by the judgment creditor to execute on the judgment before bankruptcy proceedings is to be commenced. So now I come to the position of REDA. Okay, so the position of REDA is that Ang Ming Lee should be applied prospectively, which means all transactions entered into before Ang Ming Lee continue to be governed by the law as it was conceived before the Federal Court gave its ruling. And in this case, the validity of Regulation 11(3) of HDR was never challenged for about 30 years before Ang Ming Lee. Therefore, the change in law as submitted by REDA was not foreseeable by the housing developers. And therefore, the Federal Court should invoke, or subsequent cases should invoke, the doctrine of prospective overruling. And as we can see from the case of Alvin Leong, that involved the pre-sales EOT approvals. That means the EOT was granted to the housing developer before even the SPA was signed. Okay, and housing developers have relied on the EOT approvals given by the housing controller in genuine belief that they were valid and planning their construction schedule and financing for the housing projects. All this actually is an argument in favor of prospective overruling, because in the event Ang Ming Lee is to be applied for all the EOTs that was granted to the housing developer before the decision of Ang Ming Lee, the floodgate of LED claims will come, and in fact has come. Many developers in Malaysia has received LED claims by home buyers after the decision of Ang Ming Lee, and therefore severe financial impact against the developer may trigger chain reaction that may affect the subcontractor, the main contractor, and all the downstream and upstream of the construction industry. So now I come to the issue of PJD Regency, right? So it is clear now that after PJD Regency, the date for calculation of LED starts to run from the date of payment of booking fee, not the date of SPA. Federal Court did not express that PJD Regency applies prospectively, and therefore PJD Regency applies to ongoing and completed projects, which booking fee had been paid to the purchasers. So in that regard, the developer is actually facing a huge financial impact from the LED claims arising from the booking fee that was paid by the purchasers. Taking aside the issue of whether it is legally right or wrong to take a booking fee, the issue is if the law is declared to be so that the booking fee cannot be collected, that the same argument should apply, which means that the decision of PJD Regency should apply prospectively. And then it comes to the question whether PJD Regency can be distinguished. That is a case that was before the High Court, which I was handling, that it was pre-PJD Regency. The booking fee was paid. The High Court decided that the date of the calculation of the LED should start to run from the date of the SPA instead of the booking fee. Then the purchaser appealed to the Court of Appeal. So what happened was that during the course of the appeal, PJD Regency was decided. Okay, so naturally, in this case, the Court of Appeal may overturn the decision of the High Court because PJD Regency said that the booking fee is the date upon which the LED should start to calculate. But in this case, the facts is different in the way that the delay from the collection of the payment of the booking fee to the actual signing of the SPA was caused by the purchasers for about 11 months to obtain loan. And therefore, there is no deliberate act by the developer to victimize the purchaser, which the HTA is seek to avoid. So what happened in the Court of Appeal is that the Court of Appeal held that the delay was not caused by the housing developer. The delay was caused by the purchaser, and therefore PJD Regency is distinguished. So the matter now is before the purchaser has filed for leave to appeal to the Federal Court. So it remains to be seen whether what will the outcome in the Federal Court be. All right. Okay. So now we look about what are the possible solutions that the housing developer may take in order to cushion the impact of Ang Ming Lee as well as PJD Regency. In relation to ongoing projects, it is possible for the developer, instead of seeking extension of time from housing controller, because Ang Ming Lee held that it is the housing controller that has no authority to grant extension of time. So it is possible for the developer now to seek for extension of time from the Minister of Housing and local government itself, right? Then the second is to seek for exemption under Section 2 Sub 2 of the Housing Development Act, which provides that the minister may order, publish in the Gazette, exempt any housing developer or housing accommodation from any or all the provision of this act. So this may also be one of the method or one of the considerations where the developer may consider to cushion the impact of Ang Ming Lee. And that will be all. Then I look forward for the panel discussion. Back to Dr. Lim.
Thank you very much, Niak. Due to time constraints, I think we only have time for 2 questions. So maybe I'll start with a question to Sudha, who did not get the chance to speak on Alvin Leong. Over to you, Sudha.
Okay. So Alvin Leong is different from the facts in Alvin Leong are different from the facts in Ang Ming Lee in this regard. First, in Alvin Leong, there were 2 extensions of time that were given to the developer. The first extension of time was given to the developer even before the SPAs were entered. What does that mean? That means that when the SPAs were entered into, the SPAs reflected the extended time period that had been granted, and the purchasers entered into the SPAs with eyes wide open and having consented to the extended time period. The question is whether the decision by the controller in those circumstances is still illegal and null and void. That was one of the issues that came up before Justice Wong Kian Keong, and his lordship came to the conclusion that the regulations do not provide any power to the controller to extend time. And because the regulations provide no such power, any extension of time granted by the controller to the developer is illegal and therefore null and void. The second distinguishing factor in Alvin Leong was, unlike Ang Ming Lee, there was actually a decision to grant extension of time by the minister. And the issue that Justice Wong Kian Keong had to deal with in Alvin Leong, which he said was a novel issue, having never been dealt with in any previous cases, is whether the minister has the power to extend time under the regulations. And again, his lordship came to the conclusion that the minister has no power to extend time for delivery of vacant possession, and that the terms of Schedule H are mandatory. In other words, you're stuck with the 36 months to provide vacant possession, and it cannot be extended. That would be my answer, Dato' Lim.
Sudha, can I put you on the spot? If you have a crystal ball in front of you, how would you predict the Court of Appeal will decide on 29 July?
Okay. I've always wanted to be a judge. I guess I'll now get to pretend to be a judge. So Dato', I've thought about this. My own view is, okay, you have to look at the 2 extensions of time in isolation. So let's take the second extension of time, which the minister gave. I think the Court of Appeal is likely to affirm the High Court judge's decision, because from my view, from my point of view, there's nothing in the Act or the rules that expressly gives the minister power to extend time. And the absence of such a provision is fatal. So that takes us to the first extension of time. The extension of time that was given, that was consented to by the purchasers by entering into the SPAs with eyes wide open. Now, again, the problem is this is an extension of time that was given by the controller, and there's nothing in the Act or the regulations that provides the controller with the power to extend time. So my view is that the extension of time, even the first extension of time, would be illegal and null and void. But that brings me to to a further question. Does that mean that the purchaser can still claim LAD, having consented to the extended time period to begin with? And in my view, that raises an estoppel question. But there is a problem, I feel, with the estoppel question, because the statute makes Schedule H and its terms and conditions mandatory. So the question is whether estoppel can operate against the statute, and there are many cases that seem to say that it can't be done. So for those reasons, I mean, I think it is going to be a little bit of an uphill task for the developers to succeed, but I wish them well.
And what do you think is the impact of the recent federal court decision in YKK, judgment of Justice Zabaria, insofar as any challenge to extension of time must be done by way of judicial review?
Right. Okay.
So we have some cases where the purchasers are challenging it by way of writ action. Okay, and in the Alvin Leong, there was no challenge to the first extension of time.
Yes. So the cases appear to go both ways. There are some cases that say that the purchasers must apply by way of judicial review to invalidate the EOT granted. And then there are other cases that have held that the federal court has already decided that all extensions of time granted by the controller are illegal and null and void. And this applies to all decisions. So if that is the position and to be the effect of Ang Ming Lee, Ang Ming Lee does appear to decide that all extensions of time granted by the controller are illegal and null and void, then I don't see the need for a judicial review application to be filed in each case to invalidate the specific EOT granted to the developer. They should be able to go directly by way of a writ action and sue the developer for damages. That would be my view, Dato'. Thank you.
Thank you. And Taya, there was one question. Nick Sunderland asked about CPC and CCC in standard form construction contracts. Although not directly relevant in our context of SPA, perhaps you can address it, Taya?
Yeah, so this was actually addressed in PJD Regency, where the court drew a distinction between the CPC and the CCC, and the court expressly recognized that the CPC has come into existence in Malaysia because under standard forms of building contract, the certificate that is issued by the architect under the PAM contract and the certificate that's issued by the SO under the PWD contract is called the CPC. There is a more interesting issue, which is more a construction issue as to whether if a CCC has been issued, whether in that circumstance, a CPC should be issued because the authorities have said the building is complete. Then surely the architect must also agree and issue a CPC. So that has now been dealt with in some bespoke construction contracts where they expressly differentiate the CPC and CCC and say that even if a CCC has been issued by the authorities, a CPC need not be issued by the contract administrator until and unless he or she is satisfied.
Thank you, Taya. With that, thank you very much to the panelists, and we thank our participants for staying up till rather almost 9 o'clock. We hope you have enjoyed the session. We hope you've been educated, and I think the one takeaway you would have learned from this session is how uncertain the law can be and how much more litigation there is to be done in this area of liquidated and ascertained damages. So with that, thank you very much to the speakers and also to the organizers. Back to you, Kanmani.
Thank you very much, Dato'. Thank you very much to the other panelists as well. So we've just got a very quick announcement here. Ladies and gentlemen, we would like to invite Mr. Edwin Yeo. Mr. Edwin Yeo is a senior record consultant of the Malaysia Book of Records to make a remarkable announcement for our Construction Claims and ADR Conference 2021.
Good evening, ladies and gentlemen. My name is Edwin Yeo from Malaysia Book of Records. I'm here today to make an announcement in regards to the conference that was ongoing today from the morning until now. And as an official, I would like to make an announcement that L2 Icon Sdn Bhd has made it into the Malaysia Book of Records for having the longest non-stop virtual construction and alternative dispute resolution conference for a total of 12 hours. So congratulations to you.
Thank you very much for that, Mr. Edwin. We're extremely proud and ecstatic to be able to set a record together with all of you for the longest non-stop virtual construction and ADR conference. It truly is an outstanding feat, and we thank you all for being part of it. With that, we have come to an end of our sessions this evening. Let us please invite our Tan Sri James Fong, Director of Legal Plus, who is also the Chairman of the Ombudsman for Financial Services and a retired judge of the Federal Court of Malaysia, to deliver the closing remarks.
Ladies and gentlemen, it is now 9 p.m. in Kuala Lumpur. Shanghai is also 9. London is 2 p.m. Sydney is 11 p.m. and New York is 9 a.m. It has been almost 12 hours since we began. This event in Malaysia is the longest virtual conference ever held, attracting the Malaysia Book of Records to award us this distinction. On behalf of the organizers, I graciously accept and thank the Malaysia Book of Records for honoring us. In my view, equally important is that this conference has reached out to more than 1,302 participants from 11 countries. Participants include judges, legal practitioners, where this category makes up to approximately 25% of the attendees. Building consultants, 25%, contractors, developers, and government personnel, 37%. The rest consists of students. It is great to note that the next generation is getting interested in this area of construction industry. They would be the next player to continue attending to the numerous challenges facing this trade, and hopefully they will be more innovative in their solutions. Ladies and gentlemen, I'm also very grateful to all the speakers and moderators for taking time off their busy schedule to take part in this event. Particular thanks to sitting judges who rescheduled their cases to fit the time allotted to them. A special thanks also goes to the Chief Justice of Malaysia, Tun Tunku Maimun Tuan Mat, for not only granting permission for the judges to speak at this function, but also sending a large number of honorable judges to attend as participants. Undoubtedly, they are important stakeholders in this industry. In any successful event, particularly in a conference of this size and magnitude, there are numerous personnels working behind the scene. Many have been working on this program for weeks before this event. And many of you may not be aware, after the curtain has fallen, to continue with the task of making available most of the materials discussed today by placing them on various social media platforms. Aiding this team are two directors of operation who display excellent and brilliant performance. They are Ms. Cindy Wong and Mr. Hong Kit, who are from L2 Icon. Assisting them are Ms. Jovin Tan, Daniel, Halim, and the rest of the team. Thank you very much. Special thanks to various MCs and coordinators and technicians. They have been excellent. We are also, ladies and gentlemen, greatly indebted to various sponsors for helping out in this function. Their identities are already disclosed in the program, as well as at different intervals during the screening. Their contributions are of immense assistance to us. We appreciate your very kind gesture. Particular thanks to Mr. Lam Wai Loon, one of the leading lawyers in the construction industry and a member of L2 ICON, for initiating this event. Without his encouragement, we would not have dared to undertake this venture of this dimension. Finally, ladies and gentlemen, I thank all of you for participating. Judging from the positive response, we, the organizers, are confident to declare that plans for the Construction Claims and ADR Conference for the year 2022 has begun. Hopefully, we will see you here. Thank you very much, and please stay safe. Thank you.
It was a truly amazing moment for L2 Icon and Legal Plus when we created the new record in the Malaysian Book of Records, and we could not have achieved this without you. Just as you were crucial in helping make the Construction Claims and ADR Conference 2021 a success, we and our CSR partners are grateful for your generous contribution that will go a long way in helping these organizations. Rest assured, every cent that comes in will be distributed to our 10 CSR partners. Well, all good things must come to an end, but it was a joy and privilege to have you join us once again to relive the moments of the conference while making an impact in our community. From all of us at L2 Icon and Legal Plus, we thank you and bid you farewell. Good night.